Is a personal injury case different when a child is involved? The answer to that question is yes. When a child is involved in a personal injury lawsuit, the child is subject to a statute of limitations, which is 2 years, just like everyone else. The difference is that the 2-year statute of limitations doesn't start until that child reaches the age of 18 years old. So technically, whereas if you're an adult involved in a car accident and you have 2 years to file a lawsuit, that child who may be 6, 7, 8, whatever, they have until their 20th birthday to file a lawsuit for their car accident. That's important because we all know that children are more resilient than adults, and sometimes they don't always exhibit all of the symptoms from the injuries that they've sustained. Also, some of those symptoms may develop as the child grows and gets older and starts developing through adolescence and the like. So it gives us time and it gives the family time to kind of take a whole grasp of what's wrong with the child relative to the accident, what's the injuries and the long-term consequences. Again, it's not something that we want to necessarily rush to get settled and get some money in your pocket. Even with a child, that money's going to go into a special account until they turn 18 anyway. So to see where the medical treatment goes, to see how the child progresses through that medical treatment, and ultimately the long-term result sometimes justifies taking a slower course because, again, we have up until that child's 20th birthday to even file the lawsuit. So essentially the case is the same, but the timeline is different, and that's how a child impacts a personal injury lawsuit.